amongst the masses of India. They were not interested to bring in new laws, and especially those who were in a dominating position at that particular time, the Muslims, the Mughals. So the Britishers made this exception. They said that, okay, this first part, the principles of English law, shall not apply upon Muslims. Why? Because as we know, that Muslim laws are very conservative laws. Even when this is a very generalized statement, from the legal perspective and even from the social and political perspective, there are evidence in this effect. Right, so you need to understand that that was the political scenario. Now, if we take into consideration the second part, when it comes to sale, mortgage, lease, all these things, the Britishers said no. The personal laws of the Muslims shall not overpower the English laws. When it comes to sale, you have to register if the valuation of the property is more than ₹100, if it is an immovable property. You got my point? Then whether a person is a Muslim or a Hindu or a Christian does not matter. You might not accept the principle that I am imposing, but you have to adhere to the general laws of the land for everybody. But still, there was another point that was conflicting with the Muslim laws and the British laws. And this is in perspective of gift. Gift in Muslim law is called hiba, H-I-B-A. Now there are very many connotations of Muslim gift, like it can be with condition, it can be without condition, it can be with some consideration, it can be without consideration, it can be dependent on certain contingencies, it can be dependent on the happening of certain events. There are many other categories under Muslim law. We call them hiba bil-liwaz, hiba bil-shart al-liwaz. There are many other connotations. But on one point they are same. And this says there is a concept which is known as marzul maut. Marzul maut means death, bed, gift. Okay? The Britishers stated this concept as donatio mortis causa. Okay? So this is a very unique scenario. What happens here is that, so please. Yeah, you can have a seat, please. The AC is on, and I'd like to have some more students. Please, ma'am. It's a pleasure. In all law schools, we have a set of places. I even, while I was teaching, I found the director of the law school coming up and checking up. So that's important. Well, so I was talking about donatio mortis causa, I was talking about marzul maut and deathbed gift. Now, let's identify what is the law of the Muslims in case of a situation like this. A Muslim, when gifts the property at the time of his death, okay? At the time of his death means he's in a verge of dying, and he makes a gift, or he makes a will, wasiyat, okay? Either he makes a gift or he makes a will, and then he dies. Okay? It can happen at the time of his death, he was not in the perfect sense. It can happen that he might be angry with his heirs because they were not looking at taking care of him. And it can happen that only a person who is just a mere caretaker belongs to property. Right. So in order to prevent a conflict between a third person who was not a part of the family, or might be a part of the family, wants to take the profit by depriving the other, the Muslim law comes up with this thing by saying that at the time when such transaction takes place, if at all it does happen, then the beneficiary of that transaction shall only be entitled to 1/3 of the existing property of the Muslim. Okay? That means that 2/3 of the property is reserved for inheritance. Whether there is a will or not, whether there is a deathbed gift or not. So in this way, the Muslim law tries to balance between the two scenarios. One, acknowledging the fact that the heir should have been more responsible towards the person, and also providing the benefit of or the intention of the person who made the will or the gift that he should get something.
But then this deathbed thing, how many minutes or hours prior to death?
Yeah, I'll tell you, like, it should be in a situation. This is not a question of law. This is a question of fact. The law says that it should be a deathbed gift. That means the person should die in the same ailment or under the same scenario. It can be after 1 month, it can be the next day. Okay, but the only thing that what happens in the court, we have to show that the cause of the illness is a continuation of the situation when the will or the gift was actually made. But then again, I'm telling you, this is a question of fact. Okay, but the question of law is different. The question of law is it should be deathbed gift. Okay, right? Now we come to another very important scenario, and it states that when any such gift is made, any such will is made, that will only be effective to 1/3 of the property, as I told you a little while back. But how it is affecting the Transfer of Property Act? The Transfer of Property Act is very clear, and it states, no, please.
Interesting class. I'll ask you about the same things later.
My students will be equipped to answer everybody. Okay, so what happens in a situation like that? Now I'll just tell you the other way around, carrying forward with the question that you raised. Suppose this person does not die. The gift becomes effective and 100% of the property is now gone. Suppose the person makes a gift and then die. Then 2/3 is reserved for the heirs. 1/3 goes to that person. But if he survives, then 100% is gone. Because it is not deathbed gift, and the reservation of marzul maut does not apply, and conventional gift principle shall apply, and he will be left with nothing.
So
Neither him, not his heirs. Yes.
the entire thing goes to that person?
Yeah.
Oh, okay.
If he does not die. Okay.
Everybody will die one day or the other. So, even if he's not in the deathbed, in some years prior, this does not apply.
No. If it is in the deathbed scenario and then he dies or then he does not die, then this law that I have said you right now do apply. Okay? Got it? But this is only applicable for...
This was not by deathbed giver, it was just a gift.
Then again, it is a question of fact. I told you, like, it varies from case to case, and we need to take into consideration many other factors. The point that you're raising, if the court is satisfied, then the gift might not be effective. But these are questions of evidence. So I'll discuss that with my students when I'll be teaching the law of evidence. Okay? Right. So this is the ambit of answer that you should be taking in your mind as to what extent the transfer property apply for Muslims. First part does not apply, the second part apply. But in the second part, it does not apply in the case of gift, which starts from section 120 and finishes off in 127. Okay, this 122 to 127. 7. And 127 talks about this prerogative of marzul maut or donatio mortis causa or death bed gift. Okay, so this is how you understand. Understood? Any problem? Clear? Okay. Now, what we'll be doing is we will start working on various principles that the Britishers tried to impose. Okay. So, for example, you must have come across the concept of rule against perpetuity. Limitations to transfer to unborn persons. Can a property be transferred to a person who is unborn? These are very important and cardinal questions. You getting my point? Part performance, the doctrine of part performance, the doctrine of estoppel, the doctrine of election. See, these doctrines are basically English philosophies and principles that were invoked in the Indian legal system. So when you write your answer, or you understand this question or this concept, you try to make things clear when you write the background, how why it was incorporated. In India, if you talk about the Indian property laws, you'll find that a person used to enjoy property even after his death. Even today, we have concepts like Ranji Trophy. Ranjit Singh Ji had a huge estate, and his heirs used to inherit, but in his name. In the name of the king, the Mughal emperor. This is their property. So this principle was of rule against perpetuity is something which was not known prior to the incorporation of the Transfer of Property Act. What is rule against perpetuity? 3 words: rule, number 2 against, and number 3 perpetuity. Perpetuity means a person cannot own a property after his death. Okay? So that means there cannot be a property whose ownership is vested upon a person who is not alive. Okay? A person cannot hold a property after he dies, or a property cannot be there without a person who is owning it and who is alive. If something like that comes up, depending upon the facts and circumstances, then that property vests upon the state. We call this escheat. We call this escheat. It goes to the government. The ownership vests upon the government. If there is no owner of a particular property, then it is the government who is responsible for that particular property.
Can't there be a trustee who manages the
See, a trustee is basically created by the parties. Okay? It can happen, definitely. There is an act which is called the Trusts Act. But then again, it is not the person who is owning the property after his death. It is the trust. which itself is not a living being. It is a concept. It is a separate entity altogether. And it takes care of two things. Number one, the beneficiaries and the intention of the owner who transferred it to the trustee. What was his intention? To take care of the trustees, to the beneficiaries, to take care of the property, to take care of other things. So these are the two things that's there in a trust. The trustee is vested with the responsibility of adhering with the objectives of the trust, the intention of the owner while he made this trust. You got it? This is how a trust is formed. This is, this actually happened. I think you need to know the doctrine of discovery first. Now, this doctrine of discovery is basically the initial point of colonization movement. Now, if you look into this doctrine, this study, this entire course of study, you'll find that during the 1500s, the then Pope, the Catholic Church, the main person, he saved his people, means Christians, to flourish Christianity all over the world. Okay? With this objective, the Christian countries, that is mostly the European countries, started their endeavor to conquer the world and invoke the concept of Christianity in different parts of the world.